In 2023, Meta received a fine of 1.2 billion euros. That's the largest GDPR penalty ever issued. Their mistake? Transferring European user data to the United States without proper safeguards. But here's what many people miss. GDPR isn't just about what companies must do, it's also about what individuals can demand. In this video, you'll learn the 8 rights that people have over their data, what to do when a breach happens, and how regulators decide on penalties. Let's get started. GDPR gives individuals powerful control over their personal information. Organizations generally have 1 month to respond to any request. The first right is to be informed. Before you collect someone's data, they need to know who you are, why you want their information, how long you'll keep it, and what rights they have. Your privacy notice must be clear and easy to understand, not buried in legal jargon. The second right is access. Anyone can ask if you have their data and request a copy of it. These requests have increased by over 200% in recent years. The average cost to process just one request manually is over $1,500. Having efficient systems matters. The third right is rectification. If someone's data is wrong, they can ask you to fix it. You must correct errors quickly and tell any third parties who receive the incorrect information. The fourth right is often called the right to be forgotten. People can ask you to delete their data in certain situations. For example, when the data is no longer needed, when they withdraw consent, or when the data was collected unlawfully. However, there are exceptions. You can refuse deletion when the data is needed for legal compliance, freedom of expression, public health purposes, or defending legal claims. The fifth right is restriction. Someone can ask you to stop using their data while disputes are resolved. You can still store the data, but you can't actively process it without their consent. The sixth right is data portability. People can ask for their data in a common format, like a spreadsheet, and take it to another service provider. This applies to data they gave you directly, not to profiles or predictions you created about them. The seventh right is to object. Anyone can object to processing based on legitimate interests. For direct marketing specifically, this right is absolute. If someone says stop, you must stop immediately. No exceptions. The eighth right involves automated decisions. People have the right not to be subject to decisions made entirely by computers when those decisions significantly affect them. Think automatic loan rejections or algorithmic hiring decisions. When automated decision-making is allowed, you must provide human review if requested. A data breach is any security incident that affects personal data. This includes accidental loss, unauthorized access, or data sent to the wrong person. When a breach happens, the clock starts ticking. You have 72 hours to notify your supervisory authority. This deadline begins when you realize a breach has likely occurred, not when you have complete details. If you can't meet the deadline, submit what you know and explain the delay. Regulators allow phased reporting. Start with the basics and provide updates as your investigation progresses. Your notification must include the nature of the breach, approximately how many people are affected, contact details for your data protection officer, the likely consequences, and what steps you're taking to fix the problem. You must also tell the affected individuals directly when the breach creates high risk for them. High-risk scenarios include exposed passwords, medical records, financial information, or anything enabling identity theft. You don't need to notify individuals if the data was encrypted and unreadable, if you've taken steps that eliminate the risk, or if individual contact would require unreasonable effort. In that last case, you must make a public announcement instead. Every breach must be documented internally, even when notification isn't required. This creates an audit trail that proves you're following the rules. GDPR fines follow a 2-tier structure. The lower tier covers procedural violations. Penalties can reach 10 million euros or 2% of your global annual revenue, whichever is higher. This tier includes failures like not maintaining proper records, not appointing a required data protection officer, inadequate security measures, missing breach notifications, and failing to conduct risk assessments. The upper tier covers more serious violations. Penalties can reach 20 million euros or 4% of global revenue. This tier includes breaking the core processing principles, consent failures, violating individual rights, improper international data transfers, and ignoring orders from regulators. Here's a critical detail. The percentage applies to your entire corporate group's worldwide revenue, not just the subsidiary that made the mistake. When setting fine amounts, regulators consider several factors. Was the violation intentional or accidental? How long did it continue? Did you cooperate with the investigation? What's your compliance history? How many people were affected? Did you try to fix the problem? Since 2018, cumulative fines have reached nearly 6 billion euros across more than 2,000 recorded cases. The biggest penalties have hit major tech companies. Meta has faced multiple billion euro fines for data transfers and security failures. Amazon received 746 million euros for tracking users without proper consent. TikTok was fined 530 million euros for sending data to China without adequate protections. But enforcement isn't limited to big tech. Spain alone has issued over 900 fines, many to small businesses. Common violations include sending marketing emails without consent, poor security practices, and ignoring access requests. The pattern is clear. Early enforcement from 2018 to 2019 focused on guidance and smaller fines. By 2022, regulators shifted to major penalties. The first billion euro fine came in 2023. Enforcement continues to intensify. Based on enforcement patterns, here's what matters most. Document your lawful basis for every processing activity. This is the most common reason for fines. Fix your cookie consent. Many businesses still get this wrong. Consent must be specific, informed, and easy to withdraw. Prepare for breaches before they happen. Create response procedures with clear roles and templates. Practice the 72-hour process. Implement basic security measures. Encryption, access controls, and multi-factor authentication prevent many problems. Make your privacy notice actually readable. Clear, accessible language builds trust and satisfies transparency requirements. Train your employees regularly. Staff need to recognize data requests regardless of how they're worded. Review your vendors, execute proper agreements with anyone who handles data on your behalf. Know where your data flows. Let's wrap up what we covered. Individuals have 8 powerful rights under GDPR, from accessing their data to demanding its deletion. You generally have 1 month to respond to these requests. When breaches happen, you have 72 hours to notify authorities. Document everything, even incidents that don't require notification. Fines can reach 20 million euros or 4% of global revenue. Nearly 6 billion euros in penalties prove that regulators mean business. Enforcement targets organizations of all sizes, from global tech giants to local businesses. The most common compliance failures involve documentation, consent, security basics, and responding to individual requests. Focus on these fundamentals first. Visit our platform for more resources, including breach response templates, compliance checklists, and detailed guides for handling data subject requests. Thanks for watching.